Moving on to another financial case called AG Shield. AG Shield is an interesting scenario where we have two shareholders, each own 50% of the shares of a corporation. Yet they spend roughly 23% of their time in SR&ED, and when they file the claim for SR&ED, they allocate 100% of their salary and wages to that claim. The issue became, is that reasonable under the Act? Effectively, what we're told here is that the actual time spent on SR&ED of each employee was anywhere from a low amount to almost 30%, but an average of 23%. So non-SR&ED activities represented roughly 77% of the claim. However, 100% of their wages were claimed. I've just taken the actual court documents to talk about the rationale behind it. But basically, the rationale explained in the courts was that a specified employee could be paid for SR&ED work, and that if they only accrued wages for the SR&ED work and chose not to be compensated for any other work, that this was feasible. Okay. Now, there was actually several cases, one in particular called ergo recherche, and we'll talk about another one called synchrosat, that basically looked at, I would feel, are the identical fact situations, and basically ruled differently. Found that that would not be a reasonable allocation, that over the total wages that were allocated, that the employee would actually have to claim a reasonable percentage, in this case 23% of the wages. The rationale provided by the court in this case was that the employees receive salary or dividends in lieu of salary for the other types of work. And I think that's a very dangerous position, again, because the Act talks about salary and wages being defined, as we talked about earlier, in sections 5 to the Act, which is really your earned income, not your dividend income or your investment income. So again, I'm not sure that the long-term implications for the taxpayer would be to follow this advice, other than to think of it as something interesting and perhaps look at other cases with very similar fact scenarios that went the other way. So again, a little bit of confusion, I would say, in the eyes of the taxpayer and the claimant regarding this.